4.2. Additional clauses to the lease contract. Smoking. Smoking shall not be permitted within any areas of the premises at any time. Tenant understands and agrees that any damage caused by or related to cigarette, pipe, vaping, or cigar smoking, or any tobacco product or any other product, including but not limited to snuff, chewing tobacco, or other such product, shall not constitute ordinary wear and tear. Tenant shall be responsible for any damages caused by such action of tenant or tenant's guests or invitees. An owner may deduct from tenant's security deposit for all damages and or costs for the cleaning or repairing of any damage caused by or related to any tobacco products, including but not limited to deodorizing the unit, sealing and painting the walls and ceiling, and repairing or replacing the carpet and or pads, and professionally cleaning HVAC ductwork. Noncompliance with this section constitutes a material breach of this lease agreement. Liens upon property. Tenant has no authority to incur any debt or to make any charge against landlord/agent or create any lien upon the said leased property for any work, utilities, or materials furnished to same. Application. This lease is entered into based upon information given by tenant on an application, which is incorporated into and made part of this lease. Owner may terminate this lease if tenant materially misrepresented any information provided on the application. Non-compliance with this section constitutes a material breach of this lease agreement. Conditional approvals. Risk mitigation fee. An approval can be offered to an applicant with less than perfect credit to offset the risk involved. Tenant acknowledges and agrees to pay the risk mitigation fee in addition to the monthly rent, if applicable, based on the applicant's credit approval to rent the said premises. Notices. Any notice to be given to tenant under this lease shall be deemed given when email sent to email address provided at the time of move-in, hand-delivered to any person residing at, or posted on the front door of the premises, or when deposited in the United States mail via first class or certified mail and addressed to the tenant at the premises. Tenant is responsible for reporting any changes in contact information to the agent to ensure notice will be received as previously stated in the above terms. Any notice to the given owner or agent shall be deemed given when deposited in the United States mail via certified mail or when hand-delivered and addressed to agent at the address indicated above. Furthermore, all tenants, occupants, and or others calling on behalf of aforementioned are hereby put on notice that all conversations may be recorded for quality assurance and legal purposes. Equal opportunity. Owner and agent are pledged to the letter and spirit of the U.S. policy of the achievement of equal housing opportunity throughout the nation. We encourage and support an affirmative advertising and marketing program in which there are no barriers to obtaining housing because of race, color, religion, sex, disability, familial status, elderliness, or national origin. The premises are offered and leased without regard to race, color, religion, sex, disability, familial status, elderliness, or national origin, unlawful use, disturbances, violations. Tenant or guest of tenant shall not use or permit to be used the premises, common areas, or streets for any unlawful purpose, including criminal activity or drug-related criminal activity, nor for any nuisance. Also, in the event the tenant is housing a service and or assistance animal, if there is a nuisance issue, the landlord does have the right to try to remove the assistance animal through legal proceedings as per the FHA. Tenant shall not make or permit to be made any noises which would interfere with the rights of others or their peaceful enjoyment of their property. A single violation of this provision shall be a material violation of the lease and good cause for termination of tenancy. Unless otherwise provided by law, proof of violation shall not require criminal conviction, but shall be determined by the owner's agent's good faith determination that the above provisions have been violated. Should landlord deem it necessary to issue a 21-day notice of violation for any noncompliance of the lease or other rules and regulations, and the violation is corrected within the 21 days, but repeated at a later date, the landlord can terminate the lease at the time of repetition with a 30-day notice at the discretion of agent. If the violation is not corrected within the 21 days, the lease will terminate on the 30th day, marked from the date the notice was sent at the discretion of the agent. Termination of the lease agreement for violation shall not release the tenant from obligations to promptly pay all rent due and owing, as well as other applicable lease obligations. Noncompliance with this section constitutes a material breach of this lease agreement. Other provisions. Tenant shall not place any personal belongings on the exterior of the property at any time. Noncompliance with this section constitutes a material breach of this lease agreement.